If you challenge my will or trust, you get nothing. Hi, I'm Darren Findling of the Probate Pro, and penalty clauses, also known as no contest clauses, or in the old days we used to call them in terrorem clauses, are common in estate plans. But are they allowed? Why would somebody want to add a provision in their estate plan that says that if you challenge the will or trust, you get nothing? Well, because it creates a disincentive for people to do so. So you provide that person with a gift, and you say that if you challenge the will, you lose that gift. It's a pretty strong disincentive for people to act against the estate plan. But are they legal? Are they enforceable? The answer is generally yes. Michigan has a statute, 700.2518, that specifically addresses the penalty clauses for wills, and there's also a corresponding similar statute for trusts. However, there are limitations. The limitations include that if the person had probable cause for challenging the estate plan, then it's unenforceable, the penalty clause. So imagine the scenario that you create a fraudulent will, meaning it's done with a forgery or under duress, but you give somebody a share. Could you simply say that you're going to forfeit your share if you challenge the legitimacy or the validity of the will? Well, of course not. That wouldn't be fair. So this probable cause exception exists, so it's enforceable unless there's probable cause to act. But what about the actions of the personal representative or the trustee during the administration of the trust, during the time they're serving following the death of the person who created the will or trust? What about during that period of time? Can you challenge their actions? Let's say they're not acting appropriately. Of course, the answer is yes. You can challenge it without risk of the penalty clause being invoked. So there is this aspect of probable cause as being the exception so that it would create unenforceability to this larger concept of no contest clauses. However, they are enforceable in Michigan and they're widely used. We see them almost like boilerplate language in many estate plans that are created. Do you want to use one? Well, maybe, maybe not. You should really talk to your lawyer about whether it's an appropriate tool and whether it should be included in your estate plan. I can tell you from practice that there are times people come into my office and they do want to challenge the will, or they do want to challenge the trust, the creation, the formation of that document. And those same people are provided a pretty sizable gift. They have to think hard about whether they're willing to risk the gift that they're provided for the larger objective of challenging the entire estate plan. These types of litigation issues are not simple and they're individualized, so there's not one size fits all. If you've got questions about probate related issues, visit us at theprobatepro.com or call us at 833-PROBATE.